You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 5, State of Texas versus Yolanda Saldivar. We'll talk about the 1995 murder of Selena Quintanilla-Perez, an American singer-songwriter who was known as the Queen of Tejano music. By the age of 23, Selena had broken barriers in the Tejano music industry, which until then had been dominated by men, even in the minds of the audiences. She'd won a Grammy Award and launched what would become a multi-million-dollar fashion business. In early 1995, she was about to make her crossover debut as a solo pop artist in the English language market. In February 1995, she performed at a record-breaking, sold-out concert at the Houston Astrodome. On March 31st, 1995, Selena's life was cut short by Yolanda Saldivar, a fan who wormed her way into Selena's inner circle and then took advantage of Selena's trust. And good afternoon, Kyle. How are you?
Yo, good afternoon. I'm doing well. This case hits close to home, as not only am I from Texas, but I was in college when she died, and I remember all of the folks with the Selena riding across their back windshield in honor of her when I was in college.
Yeah, it was. I mean, I remember that night. It was a Friday night, and I had turned on MTV. I think I was reading or just kind of hanging out, and I turned on MTV, and they were actually doing live shot of the Days Inn parking lot, and this was right before Saldivar ultimately surrendered. And I think I've said this before, and I'll say it again. I have had an instant dislike for very few people, but she was one where I wish that she had ended it then.
Yeah.
Rather than dragging Selena's name through the mud, as she has been doing for the last 30 years.
Yeah, and I mean, I'll say too, I'm gonna make some people mad, but like, Selena was like a sweet, super talented singer, songwriter, amazing, and then her death gave us Jennifer Lopez, who, I mean, doesn't have a ton of talent, but like Jennifer Lopez played Selena. That's how Jennifer Lopez played her in the movie. It's like, I feel like Selena should have had Jennifer Lopez's career, and Jennifer Lopez just, it's not her fault, but she's living what should have been Selena's career.
Yeah, I think, but I have to say, Jennifer Lopez did a very good job. That was a very good movie.
Oh yeah, she did. She was great. I mean, she was a good actress in that movie, and in Karen Cisco, or she played Karen Cisco. What was the George Clooney movie? I'm blanking on it, but as a singer, J-Lo's basically a
mediocre.
Doesn't have a ton of talent,
right?
But she's a decent actress.
Yeah, she is. All right, so let's get started, because there's a lot more than I thought there would be. 48 pages. So first, we're going to start with our victim, Selena Quintanilla-Perez. She was born April 16, 1971, in Freeport, Texas. Her family was living in Lake Jackson, so sometimes it says she was born in Lake Jackson. She was delivered by Ron Paul.
That's actually the greatest part of this entire case. I had no idea she was delivered by Ron Paul, but that's fantastic.
The internet is so much fun
I
sometimes.
know. If any of our listeners know who Ron Paul is, like this is actually just perfect. But you should just call it. You should end right now.
Her parents are Abraham Isaac Quintanilla Jr. He was born February 20th, 1939. And her mother is Marcela Ofelia Zamora Quintanilla. She was born July 17th, 1944. Her siblings are Abraham Isaac Quintanilla III, known as AB. He was born December 13th, 1963, which was another surprise for me, is AB and Suzette are like my contemporaries.
Mm.
And I thought they were much younger than I am.
Yeah, because she was Selena was what 5 years younger than her sister, and almost 10 years young. Well, 9 years younger than her brother.
8 years younger than AB. And Suzette Quintanilla, and I should have put her married name. She was born June 29th, 1967. Selena was educated at Orrin M. Roberts Elementary in Lake Jackson, West Oso Junior High School in Corpus Christi, Texas. She earned a GED in 1989 from the American School, and she attended Pacific, I think had a business administration degree from Pacific West University, which was a correspondence course. She was a performer and singer from 1981 at the age of 10 to 1995. She was a songwriter. She wrote Amor Prohibido, Bitty Bitty Bom Bom, and a song called God's Child, which she performed with David, what's his name? David from Talking Heads. Byrne.
Oh, yeah, David Byrne, yeah.
Okay. She was a boutique owner. She owned Selena, etc. in Corpus Christi and San Antonio, which were opened in 1994. And she was also beginning a fashion design career. Her band was Selena y los Dinos from 1981 to 1995. The members were Selena, AB, Suzette. AB was bass and backing vocals. Suzette played drums, percussion, and backing vocals. They had various members: Peter Studio, who was backing co-lead vocals, Ricky Vila, who was on keyboards, Chris Perez, lead and rhythm guitar.
Who will become a big player in this story.
Correct. Arturo Mesa, Don Shelton. I think Arturo Mesa came in and played drums when Suzette was injured and couldn't play. And they had various members. I have all of them listed, but it started out as a family band, and then it grew into so much more. Her album Selena y los Dinos had Selena y los Dinos in 1984, Alpha 1986, Muñequito de Trapo 1986, and the winner is 1987, Preciosa 1988, Dulce Amor 1988, and then Selena had solo albums as a Latin solo artist. Selena in 1989, Ven Conmigo in 1990, Entre Mi Mundo in 1992, Selena Live in 1993, Amor Prohibido in 1994, and then, of course, Dreaming of You, which was released posthumously in 1995. That was her English crossover. She appeared on some Spanish language soaps, Dos Mujeres Un Camino, Sábado Gigante, Latin Nights. She appeared as herself. And then Don Juan DeMarco, she appeared in a cameo as a mariachi singer, and that was a posthumous release. Her award, she had 86 nominations and 67 wins. She had 44 Tejano Music Awards from 1986 to 10 La Nuestra Awards, 1992 to 1994, and then posthumous 1995 and 96. 2 Grammy Awards. She had a 1994 Grammy for Selena Live, and then she had Lifetime Achievement Award in 2021, which, I mean, that says so much about her.
Yeah, I mean, she was one of those artists that really did change the game. I mean, she was one of those transcendent artists.
Yeah.
I
She
mean,
had 5
talented, yeah, just talented in her songwriting, singing, performance. I mean, she was a whole package.
She had such a strong voice, even as
And
a
her fashion
teenage
style.
girl.
Yeah, I mean, her fashion too, like revolutionized Tejano music, just her fashion sense.
5 BMI awards. Those were posthumous. And BMI, I think, is where, the music sales. So, and then she had some other awards: Billboard Music Latin Hall of Fame, ASCAP Awards for I Could Fall in Love, and she received a star on the Hollywood Walk of Fame in 2017. She married Christopher Gilbert Perez, who was born August 14th, 1969. They were married from April 2nd, 1992 to March 31st, 1995 at Selena's death. They did not have children at the time. Her injury was a gunshot wound, and she bled to death. And
I just have to say, I mean, she just seemed like, you look at her interviews, she just seemed like such a sweet person. I mean, honestly, this case makes me mad because she was just such a light.
A sweet and trusting.
All murders are tragic, but she was just such a light.
And friendly and down to earth.
Yes, she was just
and
the sweetest
that was one of the
person.
Things she always said, we, even though she was what propelled.
Yeah, she always gave credit to her band and everybody. She was just a sweet, sweet person.
And I'll mention this later. When she was about to start the English crossover journey, she agonized because she felt like she was leaving Los Dinos behind.
Yeah, I know.
And it was an agonizing decision for her.
It was never, I mean, she had some ambition, but it was really about everybody that brought her along. She was one of the few starlets that really cared about everybody that lifted her up.
Right. And she also always gave credit to the fans.
Yeah, exactly.
Because she was too accessible.
Right. Exactly.
But if you saw pictures of her house and her parents' house, they had that fence up because fans would just show up.
Right.
And they were trying to create some kind of barrier, but it was ultimately her trusting nature and her real desire to see the best in everyone, I think, is what.
Yeah, it's like her naivete, unfortunately.
Yeah. So, all right. So our perpetrator, Yolanda Saldivar, she was born September 19th, 1960 in San Antonio, Texas. Her parents are Frank Saldivar Sr., who passed away in 2005, and Juanita Saldivar, who may or may not have passed away. She was the youngest of 7 or 8 children. I have found Virginia, Armando, Maria Alida, Frank Jr., Fernando, who died in 2005, and Ernesto, who died in 2022. Maria Alida may have also died prior to 2022, but I couldn't find anything substantiating that. Now, this is something weird too. She went to Kennedy High School in San Antonio, no diploma. Holmes High School in San Antonio, no diploma. Jay High School in San Antonio, no diploma. And she finally graduated from McCollum High School in San Antonio. She also attended the University of Texas, but then transferred to Palo Alto College for an RN degree. Emotional mental. Just watched a single interview with this woman. She's manipulative. She's a liar. She's got a borderline personality disorder, and she's obsessive. She supposedly has 3 adopted children, one of whom was her niece. She has committed embezzlement against a doctor named Faustino Gomez in San Antonio in 1983 when she was working as a receptionist. And it was kind of the same situation as with Selena. She was competent. She made herself, oh, I'll take care of everything. I'll take care of this. I'll take care of that. She made herself indispensable, and then she started stealing money from him.
Yeah.
And then embezzling from Selena, Selena's fan club and Selena, etc., between 1994 and 1995. Her victim was Selena Quintanilla-Perez. So the murder occurred March 31st, 1995. The victim was Selena Quintanilla-Perez. It occurred in room 158 at the Days Inn, which is now a Red Roof Inn, at 901 Navigation Boulevard in Corpus Christi, Texas, and that is Nueces County. Selena began her music career at the age of 8, singing in her parents' restaurant, Papagayo, in Lake Jackson, Texas. The house band was made up of Selena on lead vocals with backup from older brother A.B. on bass and older sister Suzette on drums and Rena Dearman on keyboards. Their father Abraham has been accused of pushing his children into show business to fill his own unrealized dreams of musical stardom in the 50s and 60s. While the kids may have resented the hours of practice and rehearsal and the long hours on the road every weekend and some weeknights, they were talented. Selena and A.B. thrived and became successful in their own right. As a woman in a male-dominated musical genre, Selena did what many had thought impossible for a woman, especially a young woman. She realized huge success before she turned 18. Perhaps it was her voice, which was strong, expressive, and even at the age of 8, perhaps it was her perfect pitch and timing. Perhaps it was her charisma, and that enabled her to wrap any audience of 1 or 1,000 around her little finger. In 1987, Selena won a Tejano Music Award for Female Vocalist of the Year. In 1989, she landed a major record deal with Capitol EMI Latin and launched her solo career, still backed by Los Dinos. By the time A.B. had branched out into songwriting and producing. By 1991, Selena was topping Latin charts and after 2 successful studio albums and tours across the United States. That same year, she began a relationship with guitarist Chris Perez, who joined heavy metal. She attended 3 different elementary schools in the same district and 4 different high schools in San Antonio before graduating from Dillard McCollum High School. She started her college career at the University of Texas in 1985, then transferred to Palo Alto College, where she studied nursing. In 1983, she was accused of stealing from dermatologist Dr. Gomez while working as his receptionist. Dr. Gomez's lawsuit against Saldivar was settled out of court. In 1990, Saldivar received her license as an RN, and that's kind of a long time, I think, because that's like 5 years. She began working part-time after adopting her niece and 2 other children. Over the next 4 years, she worked at 3 different hospitals. She became a fan of Tejano music and initially wanted to start a fan club for Shelly Laris, whose father denied her request. When Mr. Laris turned her down, Saldivar became a fan of Selena and began calling Abraham with her request. She was persistent and kept calling him. Finally, he granted her request to start a fan club for Selena in San Antonio, Texas. The fan club brought Saldivar into Selena's life, who, in spite of her success and her many years in the music business, had been able to avoid being jaded and trusted people perhaps too easily and too much. In December of 1991, Saldivar met Selena and the two became fast friends. The entire Quintanilla family trusted Saldivar and treated her like a member of their family. Abraham didn't approve of Chris, and he didn't approve of a relationship between Chris and Selena because he feared that Chris would force his daughter to give up her career and music goals. As always, Abraham had Selena's best interests at heart. When he discovered the relationship, he overreacted, firing Chris and threatening to break up the band if Selena saw Chris again. Initially, Selena obeyed her father, but she was miserable. She and Chris resumed their relationship, keeping it a secret. Eventually, Selena realized that her father would never accept Chris, and she knew she couldn't live without him. On April 2nd, 1992, Selena and Chris eloped. Selena couldn't live without Chris and thought her father would have to accept Chris if they were married.
Yeah.
They planned to break the news, but their secret marriage ceremony didn't remain a secret. The media broke the story within hours, and Selena was stuck with the fallout. And I just want to stop. Abraham gets a really bad rap, but based on what I've seen in his interviews and in the miniseries, which I did watch, and the movie, he was a Papa Bear protecting his children.
Yeah, I mean, that's the thing. I mean, he does. Everybody gives
And
him a bad
really,
rap.
in the end, their little fingers, and they got away with so much. And all they really had to do was talk to him, and he would relent. Like
Yeah.
the scene in the movie where Selena starts dressing like Madonna with a bustier, and Abraham loses his mind. He forbids it. He's like, no, this is not going to happen. You're not going to do this. What does she do? She sits down, she talks, she explains it's fashion. She explains it's for the audience. She explains it's when you're young. And he's like, okay, fine. But she started wearing the little bolero jackets over it.
Yeah, it's like he was trying to be the protective dad, but he
Mm-hmm.
also was.
But he was
He
not
wasn't
unreasonable.
unreasonable. Yeah, he wasn't like a total. Yeah, he was just trying to be protective. But again, when she would come to him, again, at the end of the day, let's be honest, like little girl has daddy wrapped
Mm-hmm.
around her finger. So whatever she said, he's like, okay, whatever you want, Selena, because he loved her and he was just he had her wrapped around his finger.
And I think people looking from the outside in can see that. And maybe
Yeah.
they do think he was an unreasonable ogre, but
I don't
within the
think so. I
family,
just think he loved his daughter and he
and
wanted the best for her.
you got to look at it. I mean, none of the kids have left their family.
Yeah, he just wanted what was best for his daughter. And when she explained, like you said, when he talked to him, he was wrapped. He always gave in because he loved his little girl.
Yeah. So initially, Abraham was hurt by Selena's betrayal and he isolated himself. Selena and Chris moved into an apartment in Corpus Christi, and she probably wondered if her father would ever forgive her. Abraham eventually came around. Perhaps he saw that Chris wasn't going to change his daughter or make demands on her. Perhaps he realized that Selena's happiness was more important than the fears of her father. Abraham apologized to Chris, brought him back into the band, and accepted him as a member of their family. Shortly after that, Selena and Chris moved into the house next door to her parents in the modest working-class neighborhood where her parents had settled and had stayed. And that's another thing about that family. They were successful, they were making money, but they stayed in a working-class neighborhood in Corpus Christi. And I believe her parents are still there. I could be mistaken about that, but I believe her parents have stayed there. As founder and president of the Selena fan club, Saldivar was incredibly successful. By 1993, the fan club had grown to 1,500 members. Saldivar appeared to be doing a stellar job, and Abraham and Suzette were impressed. When Selena decided to open boutiques in Corpus Christi and San Antonio, Abraham suggested that she bring Saldivar in to help run the boutiques because of her success with the fan club, which had grown to 8,000 members in 3 years. Now, this was first mistake because Saldivar had no retail experience at all. And another problem, I think, is when Saldivar had the opportunity to steal, that is what she was going to do. Some describe Saldivar as one of the most efficient assistants Selena ever had. Others saw that Saldivar was desperate to impress Selena. Saldivar was possessive of Selena, placing herself between Selena and everyone else, including Selena's partner in her fashion design business, Martin Gomez. Saldivar had a reputation for firing anyone she didn't like and sabotaging those she saw as rivals for Selena's affection, including Gomez. There was also an element of obsession with Selena. Saldivar left an allegedly successful nursing career to move to Corpus Christi and run the new boutiques. Several people observed that Saldivar's apartment was a shrine to Selena. Saldivar also began abusing the trust placed in her. She wrote checks to herself from the business and fan club bank accounts. She used Selena's American Express card to rent luxury vehicles and entertain associates in fancy restaurant. She also bought herself 2 cell phones. Saldivar suggested that boutique employees chip in to buy a gift for Selena and showed them a ring inspired by Selena's love of Fabergé eggs. Saldivar took money from the employees, ordered the ring, and presented it to Selena without including the employees who'd helped her buy it. She also charged the ring on Selena's credit card.
Yes.
Selena treasured that ring and saw it as a symbol of her enduring friendship with Saldivar. Little did she know that Saldivar had paid for the ring using her credit card. I forgot I had that later.
That's terrible.
Staff complained that Saldivar was nice in front of Selena, but treated them badly when Selena wasn't around. By December of 1994, there was no money in the store accounts to pay the boutique's bills. In January 1995, staff and fans began lodging complaints with Abraham. Fans weren't getting their promotional items when they paid their dues, and staff were concerned about Saldivar's mismanagement. During this time, Selena was planning to launch a 3rd boutique in Monterrey, Mexico, a perfume line, and to expand her clothing line. Her continued reliance on Saldivar was likely because she didn't know about the problems with the Texas boutiques and the fan club. Selena was also about to begin recording her first English language album. As a testament to her kindness and character, Selena agonized over leaving Los Dinos behind when she started her solo crossover career. Between January and March, Abraham's investigation uncovered approximately $30,000 in funds embezzled by Saldivar from the fan club, the boutiques, and Selena. In some places, numbers out there. I took the most conservative one. On March 9, 1995, Abraham, Suzette, and Selena confronted Saldivar about the irregularities at the Q Productions offices. Saldivar either couldn't explain the discrepancies or her explanations were nonsensical. When asked why the fan club bank account was in her sister's name, Saldivar claimed that the bank wouldn't let her put the account in her own name, so she opened it in her sister's name. She also couldn't explain why her sister's handwriting and hers were identical. When her feigned innocence and nonsensical explanations didn't sway Abraham, Saldivar abruptly left the meeting. Abraham banned her from setting foot on Q Productions property and from contacting Selena. Selena wasn't willing to give up on her friendship with Saldivar so easily, likely because she always tried to see the good in things and the best in people. Her tenacity may have had a practical purpose. Saldivar had business records from the boutique that would be needed to prepare the business taxes, and Yolanda had taken perfume samples that Selena needed to launch her perfume line. On March 10, 1995, Selena removed Saldivar from the boutique bank accounts and as president of the fan club. The following day, March 11th, Saldivar bought a Taurus Model 85 snub-nosed revolver at a place to shoot in San Antonio. She also bought 5 hollow point rounds to load the .38 Special. On March 14, 1995, Selena told Saldivar that she could remain part of the business in Mexico, and Saldivar returned the gun. Selena traveled to Tennessee to begin recording her English album. She may have also traveled to Mexico with Saldivar. She may have traveled to Tennessee with Saldivar. The timelines are sometimes a little confusing. They did travel together during this time to one or the other.
Yeah.
And it may have been during one of these trips that Selena asked Saldivar to return the boutique records when they got back to Texas.
Yeah.
On March 24th, 1995, Selena told Suzette that she decided to fire Saldivar. On March 27th, 1995, Saldivar repurchased the Taurus revolver that she'd returned on the 14th. Saldivar was in Mexico at the end of March. On March 30th, she checked into room 158 at the Days Inn in Corpus Christi. She contacted Selena and claimed that she had been attacked and raped in Monterey. Saldivar asked Selena to come to the motel alone, but Selena brought Chris, who waited in his truck. On the way home, Selena realized Saldivar hadn't returned the bank statement she needed. Saldivar tried to lure Selena back to the motel that night, but Chris said it was too late. At the rape in Monterey than she told Selena. The nurse was reluctant to perform a SANE exam because the rape occurred in Mexico. Saldivar was a resident of San Antonio, and the hospital was in Corpus Christi. And I think the nurse was concerned about jurisdictional chain of custody issues that might arise with an exam performed not in the jurisdiction where the rape occurred and not in the jurisdiction where Saldivar lived.
Yeah, that makes sense.
And it was also probably at this point that the first seeds of doubt took hold in Selena's mind about Saldivar's stories.
Yeah,
By the
she's
time
starting to, like, she's loyal, but she's starting to be like, okay, my loyalty has some
because
limit.
when Saldivar was trying to get her to come to the hotel the night before, she told Selena she was bleeding heavily and needed to go to the hospital and needed Selena to take her to the hospital. But then when she talked to the nurse the next day, she said that she wasn't bleeding that much.
Yes, so
Pardon me.
Selena's starting to figure it out a little bit.
Yeah. By the time they returned to the motel, Selena was late for a recording session and her patience had likely run out. It's no surprise that she was angry, and no one could blame her for demanding that Saldivar stop playing games and return the bank statements, business records, and perfume samples. Selena no longer trusted Saldivar and probably let her know that. At 11:48 a.m., Saldivar retrieved the pistol and pointed it at Selena, who tried to flee. Saldivar shot her in the back. The hollow point bullet entered below Selena's right shoulder, severed her right subclavian artery, and exited the front of her shoulder. Employees saw Saldivar exit the motel room, pointing the pistol at Selena's back and calling her a bitch. Saldivar then calmly went back into room 158. Fearing for her life, Selena ran toward the hotel lobby, leaving a trail of blood behind her. She dropped her briefcase, phone, and purse along the way. At 11:49 a.m., she reached the lobby where she collapsed. Her last words were Yolanda 158. She lost consciousness as her condition rapidly deteriorated. And it's really sad. Had she dropped to the ground and stayed where she was, she may have been able to be saved.
Oh, what do you mean by that?
The exertion of running caused her to lose blood very rapidly. But she couldn't stay where she was because Yolanda wanted to kill her.
Yeah.
So, she had no choice but to run, but it was the running from Yolanda that ended up causing her
caused a bunch of blood loss.
To have the rapid blood loss, yeah. Paramedics arrived in under 2 minutes and began efforts to save Selena. They encountered problems starting IVs because of the blood loss. Blood loss had caused Selena's veins and carotid artery to collapse. In the ambulance, Selena's hand opened and the ring from Saldivar fell to the floor. Once at the hospital, she was in a grave condition. Doctors did what they could, but blood loss had deprived her brain of oxygen for too long. She did receive a transfusion, but it was too late. Selena was declared dead at 1:05 p.m. And there's some kind of rumor that because they were Jehovah's Witnesses, Abraham wouldn't let the hospital give Selena a transfusion. That is absolutely not true. Selena arrived at the hospital unconscious, and so the hospital did whatever it felt needed to be done to save her life, including giving her a transfusion. So there was no interference by Abraham with her medical treatment at all. And I think, in fact, by the time Abraham and Chris and their mother and Suzette and AB had gotten to the hospital, it was Selena had already been declared dead or was about to be declared. So that did not happen. She did get a transfusion. Now, had she survived and found out she was given a blood transfusion, but she was a Jehovah's Witness, she might have sued. Because we had a case in Tennessee where the plaintiff was, I believe, in labor and needed a blood transfusion and could not consent, and so they gave it to her, and she sued the hospital because she was a Jehovah's Witness, and that was against her religion. So, but that would have been, they would have dealt with the consequences later, but they wouldn't withhold it. Even if they knew she was a Jehovah's Witness, they wouldn't have necessarily withhold it, because sometimes Jehovah's Witnesses might consent.
Right.
Because this is a thing that's going to save your life.
Might be something you say like during the day, but when your life depends on it, you might have a different little change.
Yeah. So, and some will, even though that's the only remedy, some will deny it and not survive. But again, they didn't withhold blood because she was a Jehovah's Witness. Nobody told them they couldn't give her a transfusion, and they did do everything that they could. I mean, they brought a cardiac surgeon in to try to save her life. After murdering Selena, Saldivar tried to leave the hotel in her truck, but a responding officer stopped her. In response, she put the gun to her head and threatened to shoot herself, which began a 9.5-hour standoff. During that time, Saldivar claimed the shooting was Abraham's fault, and when that didn't gain traction, she claimed the shooting was an accident. At no point during those 9.5 hours did Saldivar, quote, accidentally, quote unquote, shoot herself. She was arrested on March 31st, 1995 by the Corpus Christi Police Department. An affidavit complaint was filed against her on April 3rd, 1995 for murder, but in some sources it's identified as first-degree murder. On April 3rd, she was arraigned. She pled not guilty. The case initially was filed in the 214th District Court in Nueces County, Texas, under docket number CR 95001187-F. The judge was the Honorable Michael J. Westgren. Saldivar was represented by attorneys Douglas Tinker and Arnold Garcia, and as far as I can tell, they were retained by her family. She was not represented by public defenders. So it was retained counsel, not public defenders. The state was represented by Carlos Valdez, the district attorney, and Mark Skirka. Bail was set at $100,000 initially, and then it was raised to $500,000 at the request of Valdez due to the embezzlement of funds and Saldivar's contacts in Mexico. A bond reduction was denied on May 18th, 1995. The case at a pretrial hearing on August 4th and August 7th, there was a pretrial hearing, and they argued change of venue, motion to suppress written statements, and motion to suppress oral statements. And Saldivar is an example of a defendant who claims things that never happened. For example, one of her claims in appeal is that they didn't put that she claimed the shooting was accidental in her written statement, and yet it says it was accidental in her written statement. She claims they kept it out of her oral statement, but in the recordings and the transcripts, her claim that it was all accidental is in the transcripts. So, on August 7, 1995, the judge transferred the case to the 228th District Court in Harris County, Texas. And so that became the new venue, 228th District Court, Harris County, Texas. The docket number is 704424. Judge Westgren remained the judge. And I think Texas is similar to Arkansas, where there's a circuit with multiple counties and multiple district courts, and the judges will rotate around that.
Yeah, I think that's right.
So
At least in the more rural areas, kind of out, outside the larger metro areas.
yeah. So she was indicted on September 28th, 1995 for first-degree murder, or murder, and then, like I said, it says first degree in some sources, but the actual papers don't say first degree. So, counsel for the state was Carlos Valdez and Mark Skirka. Counsel for the accused were Douglas Tinker, Arnold Garcia, Fred Higgins, and Patricia Sarum. The jury was impaneled on October 9th, 1995. There were 7 white, 4 Hispanic, and 1 African American. I mean, I would imagine that it would have been very difficult to find. I think they had difficulty in paneling jurors because of the notoriety of the case. So that's an interesting composition, though. Guilt or innocence phase
Well, yeah, I mean, I think she's actually lucky that she was convicted, because if she'd been acquitted, or she gets paroled, she wouldn't have survived 24 hours.
There have been, and rumors still persist that some of the gangs like MS-13 have hits out on her.
Oh yeah, I mean,
she's in spoiler alert, she's in protective custody.
If she was to get paroled, she would not survive 24 hours.
Yeah. So, the guilt innocence phase lasted from October 11th to October 23rd, 1995. She was found guilty of first-degree murder on October 23rd. And then there was a penalty phase, and the jury sentenced her on October 26th, 1995 to life. The testimony in that phase was October 25th, and then the jury deliberated and sentenced her to life. She was also formally sentenced on the same day to life. A deadly weapon finding was made, which added some years, and her sentence was set to begin on May 31st, 1995. So that's interesting, I guess, because she was arrested and had been in custody that entire time. Post-verdict motions were filed on November 22nd, 1995. There was a motion for new trial and an arrest of judgment, which was filed by Patrick J. McGuire, who would be her appellate attorney. Unfortunately, a lot of these pleadings are not available, I guess because they weren't scanning and uploading things in 1995. And federal courts don't have the full records available that far back. The motion for new trial was overruled on December 27, 1995. A notice of appeal to the 14th Court of Appeals in Houston was filed on December 28, 1995. The designation of material for the record was filed on the 29th. A motion for return of funds was filed on July 17, 1996. The state responded on November 14, 1996. And then it shows a hearing on January 13th, 1997 of another motion for new trial that I don't find any evidence of a hearing for, but that may have been the motion for return of funds. And it was just entered into the system as a new trial motion. 14th Court of Appeals was the venue for the direct appeal. The case number was 14-96-00010-CR. Her Saldivar was represented by Patrick J. McGuire. The state was represented by Adolfo Aguilo. A notice of appeal was filed by Saldivar on the 28th, which we already talked about. Okay, the points of error in the appeal were that the trial court erred in permitting the state to exercise its peremptory challenge to exclude veneer members solely on account of their race. The trial court abused its discretion in sustaining the state's challenge for cause leveled against prospective juror Gwendolyn J. Harris in denying appellant's request for additional peremptory challenges. The trial court denied her right to confront and cross-examine witnesses, the right to due process, and the right to effective assistance of counsel because the prosecution did not disclose impeachment evidence regarding the criminal history of a state's witness. Her written statement was inadmissible under the Fifth Amendment to the United States Constitution because she unambiguously requested an attorney to assist her in questioning before she surrendered to authorities, and the state did not honor her request before obtaining her statement. The trial court erred in denying her motion to suppress her written statement in violation of her right to counsel under the Fifth Amendment and the Texas Code of Criminal Procedure and Texas Constitution. The trial court abused its discretion in admitting evidence of extraneous misconduct because the state did not give adequate timely notice as required by Rule 404B of the Rules of Criminal Evidence. The trial court abused its discretion and violated Article 39.14 of the Code of Criminal Procedure by denying her pretrial request for discovery of Selena fan club records, specifically those Quintanilla acquired shortly before complainant's death from the current fan club president. The trial court abused its discretion in admitting evidence of extraneous misconduct during the guilt-innocence phase of the trial because the evidence was irrelevant and prejudicial, and the state did not prove embezzlement beyond a reasonable doubt. The trial court erred in admitting harmful hearsay regarding extraneous misconduct in violation of a right to confront and cross-examine witnesses. The trial court erred by not giving the jury a limiting instruction regarding extraneous misconduct as required by Rule 105A of the Texas Rules of Criminal Evidence and by refusing her request to instruct the jury in the court's charge as to the limited use of the extraneous offense evidence and the standard of proof it must apply in considering the evidence. 11 was the same as 10, which I don't know quite how. I base this on I got this from the opinion, so I don't see quite how these things were presented by Saldivar. The trial court did not properly inform the jury regarding the voluntariness of her conduct by overruling her objection to paragraph 6 of the jury charge and by refusing a requested instruction on the issue. Basically, she wanted to argue she didn't have intent. The trial court abused its discretion in admitting irrelevant and prejudicial opinion evidence during the punishment phase. The trial court committed reversible error in overruling her objections and denying her motion for mistrial based on a prosecutor's comments on her failure to testify. The trial court erred in denying her request for an instruction and a special issue regarding sudden passion. And that was 15 and 16 were the same. And she's entitled to a new trial because the documents related to the extraneous offense were lost or destroyed without her fault. Now, the issue of voluntariness apparently went back to the trial court, which entered findings of fact on July 2nd, 1998, finding that Saldivar's written and oral statements made on March 31st, 1995 were admissible. Saldivar was warned of her Miranda rights and signed her written statement. Saldivar was not forced, coerced, or threatened into signing her written statement as reflected in that statement. As to Saldivar's oral statement, she was not in custody or being interrogated at the time she claims to have invoked her right to counsel. The negotiations between Saldivar and police did not constitute custodial interrogation. There was never any clear, unambiguous invocation of her right to counsel during the standoff. On October 1st, 1998, the appellate court rendered its decision. They overruled all points of error and finding no reversible error, they affirmed the judgment of the court below. A motion for rehearing was filed on October 13th, 1998. That was denied on December 10th, 1998. McGuire filed a motion to withdraw his counsel of record on December 15th, 1998, and a motion for hearing. A motion for return of property was filed on January 8th, 1999. A petition for discretionary review was filed with the Texas Court of Criminal Appeals under docket number PD 0515-99. The grounds were prosecutorial misconduct for withholding evidence, an illegally obtained confession, jury instruction not given, and then also she mentions a challenge to the jury veneer. Response was filed by the state on May 6, 1999. The petition for discretionary review was refused on August 18, 1999. The mandate issued on September 7, 1999. The mandate of the 14th Court of Appeals issued on September 22nd, 1999. And Saldivar's conviction and sentence became final on November 13th, 1999, when the time to file a petition at the U.S. Supreme Court expired. So, and now we move on to state post-conviction. Any questions? Any thoughts? Oh dear, Kyle's gone. I've been talking to myself. Oh Lord. All right. Well, I guess he will just. Oh, there he is. You back?
I'm sorry. I know I'm having weird stuff with StreamYard, but yeah, I was there. No, I think it's I mean, it's such a clear-cut case. I mean, yeah, we got to go all through the legal stuff, but I mean, it's like,
oh, it gets even more
you're just
interesting.
wasting time. I mean, it's no doubt about it. I mean, she literally killed her in cold blood, and it's just such a it's ridiculous that we have to waste state resources on all this crap.
Yeah. I'm taking a minute to grab another drink because I'm really thirsty, and I forgot to refill it before I started this. Before I got this show on the road, so I'm gonna get another drink real quick. Take a break. But yeah, her direct appeal. Now, she's been representing herself for several years, so it's a shit show.
I mean, the only representation she needs to do of herself is to be glad that she's in prison, as I said earlier, because if she was out, she'd be dead in 24 hours. I mean, she's probably the most hated person in the state of Texas.
Yeah. One of the rumors was the MS-13 was going to bail her out and then kill her.
Yeah. They probably would torture her and then kill her.
Yeah. So,
I mean, she probably should just be quiet and be happy that she served. I'm honestly surprised she stayed in prison this long. Like, I thought somebody would have shanked her 20 years ago.
She's been in like administrative segregation. She's housed on their death row.
I mean, because she's literally the most hated woman in Texas.
Yeah. And all right, so we move into state post-conviction. Now, this is where it gets complicated. The correct venue for state post-conviction was the 228th District Court in Harris County, Texas, under docket number 7044240101-0-3. Her counsel was Suzanne Kramer and William Bershelman, Alan Manka, Roland Moore. These were attorneys apparently retained by her family. And then she began representing herself pro se. She claims a petition was filed on September 23rd, 2000, allegedly in Nueces County, but that was the wrong county. But it was filed on behalf of Saldivar, according to Saldivar and her attorneys at the time. But it's unclear whether this was filed by Saldivar pro se or by Bershelman. Saldivar received her records from Bershelman prior to his death in 2003, and she references a certified mail green card in support of her allegation that a state writ of habeas corpus was filed, but she's never produced a file stamp copy of the pleading in support of her allegations. The Nueces County District Clerk has been ordered to check their records twice, and they've not found a copy. She's tried to rely on a copy that was sent as a courtesy copy to the judge, but it's not a filed copy. So it was filed. Her attorney filed it in the wrong jurisdiction, and he may have messed up and not really actually filed it with the clerk. So on October 26, 2000, an order returning cause to county of original venue and to the district court to transmit papers to such county was entered based on certificates of counsel signed on October 20th, 2000 by Suzanne Kramer on behalf of Saldivar and Carlos Valdez on behalf of the state. That was signed by presiding Judge Poe in Harris County. On December 20th, 2000, a letter was sent by to the Nueces County District Clerk, and an index of the record was sent by Donna Vallis, the supervisor of the criminal post-trial Harris County, to Oscar Solis, the district clerk of Nueces County. That was on December 20th. A certificate of receipt was signed and returned on January 9th, 2001, certifying receipt of the records from Harris County by Deputy District Clerk Sylvia Josso and Anna Cazares. And that was the criminal department supervisor in Nueces County. A motion for destruction of seized property was filed in Nueces County on June 3rd, 2002 by the state seeking destruction of the handgun used in the murder. An order for destruction of seized property was entered on June 6th, 2002 by the court, and the handgun was destroyed by the Nueces County Sheriff's Department with Abraham and Suzette in attendance on June 9th, 2002. And interestingly enough, the attorneys representing Saldivar at this time said, well, we're going to just let this happen. And then if we get a new trial, they don't have the murder weapon anymore. And the order for destruction of property was returned on June 11th. A hearing was held on July 30th, 2003 on a motion on returned funds and state's motion for additional court costs. Because apparently Saldivar was trying to get funds that were seized returned to her. And what happened was the court found that the funds belonged to the defendant, but further finds that the court costs were due and therefore ordered the district attorney's office to turn the money over to the district clerk to be applied toward the court costs, and then a receipt made out to Yolanda Saldivar.
So it's basically like a wash. So she they were owed, she was owed money, but she'd spent it more than that. So
yeah. And at this point, Saldivar becomes her own attorney. She begins representing herself pro se. And so she's trying to pursue her state post-conviction claims. She files a writ of mandamus in the Texas Court of Criminal Appeals under docket number WR-69661-01. It's a motion for leave to file writ of mandamus on April 2nd, 2008, because she's trying to pursue her federal habeas claims, but she's got to exhaust her state rights. And on May 21st, 2008, leave to file was denied without written order. She also, on April 1st, filed a petition for writ of habeas corpus by a person in state custody, which was pro se. The grounds she argued were conviction obtained in unconstitutional, prejudicial, and purposefully manner in selecting jurors, conviction obtained in violation of applicant's due process, Sixth Amendment right of effective confrontation and cross-examination, conviction obtained by the use of an unlawful obtained confession after invocation of rights, conviction obtained in violation of a substantial right to instruct jury on admitted extraneous offenses, conviction obtained in violation of a constitutional right against applicant's failure to testify, and conviction obtained in violation of the 6th and 14th Amendments of the United States Constitution on jury instruction on sudden passion. So it goes from being an accident, it goes from being Abraham's fault, even though he wasn't even there, to an accident, and now sudden passion at trial. So her stories be a changing.
yes, it always does.
And she filed a memorandum in support of her petition that argued that the Court of Appeals unreasonably applied clearly established federal law as determined by the United States Supreme Court pursuant to Batson versus Kentucky, in failing to recognize applicants' valid challenge and determining that trial counsel failed to timely preserve the complaint. The state exercised its peremptory strikes in a purposely prejudicial manner and failed to prove a racially neutral reasoning for doing so. And unfortunately, I'm not quite sure I don't know whether she was trying to argue not enough Hispanics on the jury, or that too many Hispanics were peremptory challenges, were eliminated by peremptory challenges, although that really would inure to her benefit because Selena was bigger with the Hispanic
Right. Yeah, they're playing the race
populace.
card seems kind of silly since she was Mexican, killed a Mexican.
Yeah.
Seems kind of just
But
kind of
not
a silly
apparently she's
distraction.
arguing she may be, and I'm not really sure. And because these are pro se, and because Yolanda is, you would think she was a lot smarter being a nurse, but not really.
Yeah,
She tends to ramble, and she tends to
Right.
include a lot of extraneous, irrelevant information that detracts from whatever her arguments may or may not be.
Right.
So I'm not sure if she's arguing too many blacks were excluded, too many Hispanics were excluded.
I just think she's arguing to try to find a way to distract the legal system.
That's true too. All right, so appellate court unreasonably applied clearly established federal law in holding applicants' due process Sixth Amendment right of effective confrontation and cross-examination was not violated. The applicant was harmed when the Court of Appeals upheld the trial court's failure to grant the motion for new trial based on newly discovered, wrongfully withheld impeachment evidence pertaining to one of the state's main witnesses. The Court of Appeals unreasonably applied the law interpreting the Fifth and Sixth Amendments of the United States Constitution in holding that the trial court did not err in failing to suppress the applicant's written confession obtained after invocation of rights. The appellate court erroneously reasoned that the applicant's request to speak with an attorney was not unambiguous and that she was not in custody at the time she made the request. The Court of Appeals unreasonably applied clearly established federal law as determined by the United States Supreme Court in overruling applicant's point of error that she suffered harm from the failure of the trial court to instruct the jury about the limited purpose for which evidence of extraneous offenses was admitted. The Court of Appeals erred by failing to discern the difference among a preserved charge harm analysis, unpreserved charge harm analysis, and a Rule 44 beyond a reasonable doubt harm analysis. The appellate court unreasonably applied clearly established federal law in holding that the prosecutor's comments did not amount to an impermissible comment on the applicant's failure to testify in violation of the applicant's rights under the Fifth Amendment of the United States Constitution. The Court of Appeals erred in overruling applicant's point of error wherein she asserted she suffered harm when the trial court denied the requested punishment instruction of sudden passion pursuant to Texas Penal Code Title V, Chapter 19.022 and 19.023, in violation of the 6th and 14th Amendments of the United States Constitution and Article 1, Section 10 of the Texas Constitution. So the response filed by the state was a motion for summary judgment with a brief in support that basically argued procedural bars. Nueces County has no record of the pro se 11.07 petition Saldivar claims to have filed. The Texas Court of Criminal Appeals has no record of the state habeas application Saldivar claims to have filed on September 23rd, 2000. And that's important because when a state writ for post-conviction relief is filed in Texas, the district clerk transmits it to the Texas Court of Criminal Appeals. And then the district court decides if it's going to hold a hearing, if it's going to...
Is that transfer like instantly, or how long does that take?
It generally is within a day or two.
Okay, so it's pretty quick.
Because they send the writ and whatever exhibits are filed with the writ.
Gotcha. So it's not like a long, drawn out, like 9-month process.
Right. And in the first with the first application, the district court either decides to hold a hearing or doesn't hold a hearing and enters findings of fact and conclusions of law based on the record, and then transmits it up to the Texas Court of Criminal Appeals. They either recommend relief or they recommend denial of relief. But the Texas Court of Criminal Appeals has the last say in that process. So, they're involved in that process. So not only is there no record in Nueces County, there's no record in the TCCA. Outgoing prison mail logs do not indicate that Saldivar mailed any legal documents to any court between August 1st, 2000 and October 15th, 2000. The statute of limitations is a threshold issue that precludes any consideration of the merits of Saldivar's claims. Saldivar's petition is barred by the federal habeas corpus statute of limitations, and any inquiry into exhaustion is unnecessary to the resolution of this motion. Saldivar's claims are barred by the statute of limitations embodied within AEDPA, which basically says if you don't file a state writ, you have 1 year from your conviction becoming final, which is the expiration of the time to apply to the U.S. Supreme Court to file a federal habeas corpus writ. And the statute started to run when her petition for discretionary review was refused on August 18th, 1999, which isn't necessarily correct, but it expired long before April 2nd or April 1st, 2008. Saldivar had 90 days from the time the TCCA refused her petition for discretionary review to file a petition for review by USSC. Her conviction became final on November 16th, 1999. She had until November 16th, 2000 to timely file a federal habeas corpus application challenging her conviction. If she filed a state application in the 214th district for Nueces County, it would have been improperly filed because she was tried in the 228th district court for Harris County. And that's an important thing. If you file in the wrong county, it's like you never filed.
Yeah, it's kind of like the West Memphis 3, Michael Hutchison filing for the DNA results, but intentionally filing in the wrong county just to delay, and so he can raise funds but not actually have to go through the process.
Right. And this too, if she had filed the timely application, it would have stopped the clock on federal habeas until that process concluded. So Saldivar cannot claim that a properly filed application for state post-conviction or other collateral review with respect to the pertinent judgment or claim should toll her deadline for filing the instant petition. Saldivar is not alleged, and the record does not reflect that any unconstitutional state action impeded her ability to file this petition earlier, or that her claims concerned any newly recognized constitutional right made retroactive to cases on collateral review as announced by the United States Supreme Court. Therefore, the court should dismiss the instant petition with prejudice as time barred. Saldivar is not shown, nor can she show, that she was actively misled in any way or that the state created extraordinary circumstances to justify equitably tolling her case. Saldivar never filed a state application and waited over 8 years from the time her conviction was final before filing the instant petition. Saldivar's petition is untimely as a matter of law and should be summarily dismissed with prejudice as time barred. And, one thing I want to also point out, during the time her direct appeal was pending, her family actually hired an attorney who was supposed to gather, quote, new evidence that Yolanda claimed would exonerate her, which was allegedly a diary belonging to Selena and videotapes that would have damaged Selena's career. Because Yolanda's story is that she was attacked in Monterey by people who wanted to get these things to hurt Selena, which makes no sense.
Yeah, she cray.
And so they hired this attorney, And in 1998, they sent him on a wild goose chase in Monterey, going to banks looking for the diary and videotapes that Yolanda claimed were in a safe deposit box in a bank in Monterey.
I mean, she's just dreaming stuff up, new excuses.
Other attorneys during this period of time who were on similar wild goose chases who withdrew, and that's why she's pro se. So, on January 26, 2009, Saldivar filed a response with exhibits and basically argued that on June 27, 2003, her sister Maria Alida Saldivar purchased records on the case and inquired about Saldivar's 11.07 application. She claims she met with Assistant District Attorney James D. Rosenkild, and he informed her of its status. She was accompanied by Ruth Sosa, who witnessed these events. She claims to have green cards to prove filing of state habeas corpus application, but does not include them with her exhibits. She attaches exhibits, complaints about her legal mail made in 2008, which has no relevance to 2000. A 2003 receipt for copies purchased by Maria Alida, and a card from Rosenkild, an affidavit of Maria Alida claiming that she asked Rosenkild about the status of Saldivar's 11.07 application, that Rosenkild showed her a box on the floor containing Saldivar's application and told her it would take 2 to 3 years for anyone to look at the appeal, or that it might just be ignored. And an affidavit from Sosa also saying basically the same thing. That Rosenkild showed them a box on the floor, said it would take 2 to 3 years for anyone to look at it, or it just might be ignored, which isn't true. That's not true. That's not how it works.
Yeah, it's she appeals. I mean, she's just throwing anything she can against the wall, it feels like. I mean, it's actually exhausting just listening to it. My brain hurts.
How do you think I felt?
I know.
You need an extra week.
I'm left-handed. I should get out of prison.
Yeah. So on February 2nd, 2009, the court issued the opinion and order. Yeah, the court issued an opinion and order. In conclusion, based on the competent summary judgment evidence before the court, there is no record that an Article 11.07 state post-conviction writ of habeas corpus was ever filed by or on behalf of petitioner. Therefore, this court concludes that unless equitably told, petitioner's federal writ, which was not filed until March 27, 2008, is time barred by the 1-year limitations period. Even assuming that there was some evidence that petitioner's attorney intentionally deceived her that he filed the article of any of her attorneys regarding the delay. Notably, while bearing the burden of proof on this issue, petitioner submits no correspondence between either herself or her family and her attorney regarding the status of the state post-conviction habeas corpus writ that was allegedly filed. Petitioner has simply not shown rare and extraordinary circumstances, as is her burden, that warrant equitable tolling. Under the circumstances presented, this court simply cannot find that petitioner diligently pursued federal habeas relief. As the Fifth Circuit has noted, equity is not intended for those who sleep on their rights. This court therefore concludes that the petitioner is not entitled to equitable tolling, and her federal petition for a writ of habeas corpus must be dismissed as time barred. For all the foregoing reasons, the court concludes that respondent's motion for summary judgment is granted, and that the petition for writ of habeas corpus of Yolanda Saldivar is dismissed with prejudice as time barred, and to the extent filed, any pending motions are hereby denied. A judgment was entered dismissing, and it was a final judgment on February 2nd, 2009. Saldivar on February 13th filed an objection to the magistrate judge's final judgment, and it was the magistrate judge, not the district judge. She insists that a state writ was filed on September 23rd, 2000, and that she can prove it although she doesn't submit the card that proves receipt of the state court writ. She argues that the magistrate judge erred in dismissing her federal petition and requests a certificate of appealability. And, when you look at the statements from Maria Alita and Ruth Sosa, this was in 2003, so allegedly 3 years after it was filed on September 23rd, 2000. So it had already been 3 years. And Maria Alita is getting state court records, so why isn't anything done in 2003? Because it didn't happen. I really think her family are as bad as she is. And they're supposedly were a good family, but where it comes to her, they're as bad as she is, because they're going to lie for her. And anybody who watched the Oxygen, Selena and Yolanda, or Yolanda and Selena, whatever the frick they called it, will see that, obviously.
Yeah.
She filed a supplement to her objections on February 17, 2009, claiming that the state is preventing her from pursuing her federal habeas claims by failing to rule on her state habeas writ. She ignores the fact that if the state court petition was filed in Nueces it was filed in the wrong jurisdiction, that neither the district clerk in Nueces, the district clerk in Harris, has a record of the writ filed in 2000, and CA doesn't have a writ. She submitted a correction on February 18, 2009, which claimed that she raised an allegation that state imposed an unconstitutional impediment to filing of a petition for writ of federal relief. But that was more, that's her allegation that they haven't acted on her imaginary petition that nobody has a record of. She filed a notice of appeal on February 20th, 2009. An opinion and order was entered on February 24th, 2009. In petitioner's motion, she requests the court reconsider the decision that her federal writ of habeas corpus is time barred, and in the alternative, reconsider the decision that she is not entitled to equitable tolling. Petitioner attaches numerous exhibits to her motions which she contends support her position. However, in reviewing petitioner's motions, along with her exhibits, only solidifies the court's conclusion that petitioner's federal writ of habeas corpus is time barred. Moreover, petitioner's assertion that the state created impediment existed since the state never ruled upon her Article 11.07 state writ of habeas corpus actually filed on behalf of petitioner, nor does petitioner offer any competent summary judgment evidence of its filing. Finally, even considering petitioner's motions and the attached exhibits, the court once again finds that no exceptional circumstances exist which would warrant equitable tolling in this case. The court therefore concludes the petitioner's motion for reconsideration must be denied and therefore are hereby denied. And on the same day, the court entered an order denying a court certificate of appealability, since petitioner has not shown that this court erred in its determination that her habeas corpus claims were time barred, and since the court carefully reviewed her objections, construed by this court as motion for reconsideration, which only further confirmed her claims were time barred, it is ordered that a certificate of appealability is denied. The case was, a notice of assignment was issued by the Fifth Circuit Court of Appeal on March 11, 2009, assigning docket number USCA 0920109. She filed an application for a certificate of appealability on March 27th, claims that her state court writ was received by the convicting court on September 26, 2000, based on agreed card never produced to the U.S. District Court. Also states that the second petition for writ of mandamus will be filed at the Texas Court of Criminal Appeals. Her grounds are conviction obtained in violation of constitutional right to due process, Sixth Amendment right to appeal, conviction obtained in violation of petitioner's due process Sixth Amendment right of effective cross-examination and confrontation, conviction obtained by the use of an unlawfully obtained confession after invocation of rights, conviction obtained in violation of the 6th and 14th Amendment of the United States Constitution on jury instruction and sudden passion. And the 14th Amendment only applies to federal amendments to the states. Conviction obtained in violation of substantial right to instruct jury on admitted extraneous offenses. Conviction obtained in an unconstitutional, prejudicial, and purposely manner in selecting jurors. Conviction obtained in violation of a constitutional right against petitioner's failure to testify. She filed a second writ of mandamus under docket number WR 69-66102 pro se in the Texas Court of Criminal Appeals on April 6, 2009. An order was entered on April 22nd, 2009. In these circumstances, additional facts are needed. The respondent, the district clerk of Nueces County, is ordered to file a response, which may be made by submitting the record on such habeas application, submitting a copy of a timely filed order which designates issues to be investigated, by stating the nature of the claims asserted in the application filed by relator is such that the claims are not cognizable under Texas Code of Criminal Procedure 11.07, or stating that relator has not filed an application for habeas corpus in Nueces County. This application for leave to file a writ of mandamus shall be held in abeyance until the respondent has submitted the appropriate response. Such response shall be submitted within 30 days of the date of this order. On May 15, 2009, a supplemental record was filed with the Texas Court of Criminal Appeals. A second supplemental clerk's record was filed on June 1st, 2009. And on June 10th, 2009, relator has filed a motion for leave to file a writ of mandamus pursuant to the original jurisdiction of this court. In it, she contends that she filed an application for a writ of habeas corpus in the 214th Judicial District Court of Nueces County on September 26, 2000, and it has never been forwarded to this court. Applicant was originally indicted in Nueces County, but the case was then transferred to Harris County for trial. This court held this mandamus in abeyance and ordered Nueces County to respond to relator's claims. The timeline for this case has now been established, and we find that relator is not entitled to a mandamus relief. This case was transferred to Harris County for trial on August 18, 1995. Applicant was convicted in Harris County, cause number 704424, on October 26, 1995. The case was not transferred back to Nueces County until November 21st, 2000, when Harris County agreed to transfer the case back to Nueces County. Relator alleges that she filed her application for writ of habeas corpus in Nueces County in September 2000. If true, then the filing would have been in the wrong county at that time. Relator was convicted in Harris County and therefore needed to file the application with that district clerk's office. Relator does not allege that she ever filed the application in Harris County, nor does she allege that she filed the application in Nueces County after the case had been transferred back from Harris County. Relator has not shown that she ever properly filed a post-conviction application for writ of habeas corpus in the county of conviction. Therefore, this application for leave to file is denied. She filed a motion for reconsideration on March 23rd, 2009. That was disposed as no action taken on June 23rd. On June 24th, no action was taken. It was disposed of. She appealed to the Fifth Circuit Court of Appeals. The record on appeal was received on June 9th. And then she filed a motion for, she went back to the district court. She wanted a motion for leave to file writ of error to reverse this court's final judgment order of February 2nd, 2009 on July 13th, 2009. An order was entered on July 27, 2009, having considered the merits of petitioner's motion. This court is of the opinion that the petitioner's request for relief must be denied. As discussed in this court's February 2nd, 2009 order, Petitioner's federal writ of habeas corpus is time barred, regardless of petitioner's attempts to create nuances. The summary judgment evidence establishes that an Article 11.07 state writ of habeas corpus was not properly filed by petitioner's attorney, which she retained in either Harris or Nueces County, Texas. In addition, despite numerous exhibits that accompany petitioner's motion, this failure cannot properly be attributed, as petitioner attempts to argue, to the state, nor did the state create any impediment that prevented her attorney from properly filing her state writ of habeas corpus. Petitioner's federal writ, filed 8 years after her conviction became final, is late and therefore time barred. While petitioner reiterates that she's entitled to equitable tolling in this case, as previously discussed by the court, an 8-year delay simply does not support her bald claims of diligence, nor will any alleged negligence on the part of a retained attorney suffice to warrant equitable tolling. Accordingly, having fully considered petitioner's motion, the court concludes that it should, and it is hereby denied. In addition to serving the parties, a copy of the order shall be forwarded to the Fifth Circuit Court of Appeals. And then another order is entered on October 7th, 2009 in the Fifth Circuit Court of Appeal. I should have indicated that. Sorry. Saldivar's conclusional allegations that she filed a state application for post-conviction relief in the 214th Judicial District Court of Nueces County, Texas, on September 23, 2000, and the state courts have failed to take any action on her application, are insufficient to warrant habeas relief. Further, contrary to Saldivar's contention, the district court considered and rejected her arguments that the state created an impediment to filing the 2254 application by refusing to rule on her state habeas application. Therefore, Saldivar has failed to show that reasonable jurists would debate the district court's procedural ruling, and this court need not reach her substantive claims. Accordingly, Saldivar's COA motion is denied. So she's not given up. Spoiler alert. She goes back to state court in 2010, and she files a subsequent state post-conviction claim, 11.07 habeas corpus, in Nueces County and in the Texas Court of Criminal Appeals. And that's under docket number WR-69661-03, and that is pro se. I don't have the actual application. She files on January 25th, 2010, the application for 11.07 writ and memorandum in support. The state filed an answer on February 19th, 2010. The state submitted proposed findings of fact and conclusions of law. An order was entered on February 19th, 2010 by the court, which I'm guessing adopted the state's proposed findings. I don't know what her claims were because the records aren't online. A writ transcript was transmitted by the Nueces clerk on March 1st, 2010 to the TCCA. The TCCA disposed of the writ, was denied without written order on the trial court findings without a hearing. A motion for reconsideration was filed on March 30th, 2010 by Saldivar. No action was necessary because it did not comply with Rule 79.2D. So that was on March 31st, 2010. She then goes back to the U.S. District Court, but she goes, instead of the Southern District, which is actually the proper venue, she goes to the Western District with a writ of habeas corpus, claiming that prison officials violated her due process rights in a disciplinary action. She claims prison officials violated her liberty interest protected by federal established law under the 5th and 14th Amendment of the United States Constitution and Texas Constitution by imposing unmerited disciplinary action against petitioner, resulting in lost privileges and property. Petitioner was under the discretion of a TDCJ official designee, Lieutenant Bailey's decision-making and policy change. Prison officials violated her protected property rights in a disciplinary action. She was basically, all of her printing apparatus, typewriter, and pens were removed from her possession, which interfered and prohibited her from completing her appellate post-conviction agenda in state court through the court system. They violated her Eighth Amendment prohibition in disciplinary action. So she claiming a host of medical issues resulting from the heat, and apparently a fan was taken away from her. She filed a memorandum in support detailing all the alleged violation by the prison officials, which isn't really a proper HC. That's more like a civil rights complaint. A report and recommendation was issued on February 17, 2012, and that found that having carefully reviewed the pleadings, it is a recommendation of the undersigned that the instant petition be denied. An order was entered adopting the magistrate's findings and ordering the writ be denied, and that any pending pretrial motions that hadn't been decided were denied denied as moot in light of the court's dismissal. A judgment was also entered on April 16, 2012, dismissing the case. She goes back to the state court for another writ of mandamus, WR-69661-04. She basically is seeking an order requiring the Nueces County District Court clerk to advise her of the total cost to purchase the clerk's record and reporter's record from her trial. The TCCA holds that in abeyance and orders the district clerk to file a response. On December 15, 2013, they sent a reminder letter to the clerk because no response had been received and requiring a response to the motion. At the same time, she's going back to the federal court with mandamus and writ of mandamus and habeas corpus, again in the Western District, claiming that the district court cannot locate her state court trial record and the TCCA has not taken action on her writ of mandamus. With such behavior, it only lends petitioner and others to speculate or assume that something may be wrong with petitioner's trial records being lost, destroyed, or expunged. Her grounds are her right to appeal invoking due process of law is affected by inaction of a state district court, and she's protected against the arbitrary and oppressive exercise of judicial power by the substantive due process clause. She seeks that the convicting district court provide her with the ability to purchase her record, her complete criminal record. If the criminal records are lost, destroyed, or expunged, she seeks a new trial. And then she also argues that the petition is timely based on new evidence. The order is entered on February 13, 2014. The federal district courts do not have jurisdiction to issue writs of mandamus against a state actor or agency. The court, therefore, lacks jurisdiction to grant petitioner's request for mandamus relief because she seeks issuance of a writ against state actors or agency. To the extent that petitioner seeks federal habeas relief under 2254, this court also lacks jurisdiction to consider a second or successive petition. On April 1st, 2008, petitioner previously filed a 2254 habeas application seeking to challenge the same conviction in the United States District Court for the Southern District of Texas. By final order and judgment entered on February 2nd, 2009, the court denied and dismissed Saldivar 1 as being time barred. The Fifth Circuit Court of Appeals subsequently denied her a certificate of appealability. So EDPA creates a gatekeeping, which means the Fifth Circuit has to authorize this subsequent. So they dismissed this action for lack of jurisdiction, and they ordered that no certificate of appealability would issue as she's failed to make a substantial showing of the denial of a constitutional right. And so a judgment was entered on February 13, 2014, dismissing and denying her writ of habeas corpus. She filed another 11.07 writ at the Texas Court of Criminal Appeals on under docket number WR 69661-05 on January 8, 2015. It was dismissed on March 4th, 2015. See Article 11.07, Section 4. She went back, the 04 writ of mandamus resumed when the TCCA basically threatened Nueces County to respond. They issued a letter, notice, and order to show cause on November 14th, 2015. Now, therefore, it is ordered by the Court of Criminal Appeals that respondent shall file an appropriate response and show cause. Excuse me. Oh. All right. Are you still awake? Kyle? Kyle, did you fall asleep? Kyle. Kyle. Oh my goodness.
Yes, ma'am. Sorry,
I am so sorry. She's so boring. You dozed off. All right. We're gonna stop. We're gonna stop torturing. I'm gonna stop torturing you. I'm gonna stop torturing myself. I'm gonna stop torturing the listeners. Okay, so the writ of mandamus, the clerk eventually filed a response, and basically the administration had changed, and the new administration wasn't aware of the email address where the TCCA was sending communications. They filed a response. The cost of her complete trial record was $11,013, and so they filed their response, and the Court of Criminal Appeals dismissed her mandamus and her motion to show cause, and the motion to show the show cause rule against the Nueces clerk. She filed a civil rights complaint in federal court in Western District, because I guess that's where the prison is, alleging she was assigned an unsafe cell that included a top bunk that she had difficulty climbing up and down into. She supposedly fell and hit her head, and was suing for $250,000 in compensatory damage and $250,000 in punitive damages. These pleadings were especially painful because she just rambles on and on and on. So basically, the court entered an order on June 20th, 2016, finding that the medical entity was immune from suit under the 11th Amendment, that the prison officials were immune from suit under the 11th Amendment in their official capacities, that she didn't state any claims against any of the prison administrators in their individual capacities, and that her negligence claims were not cognizable under Section 1983, that she failed to show an abuse of a government power that rises to a constitutional level, and that negligence on the part of jail officials does not give rise to civil rights claims, and they ordered her action dismissed. She filed her writ of mandamus. She sent a letter on the 404 writ of mandamus requesting status on July 15, 2016, and they sent her a letter back saying that it had been denied on January 13, 2016, without a written order. She filed a notice of appeal on the civil rights complaint on July 18, 2016. The court affirmed the district court dismissal and held that Saldivar's allegations do not demonstrate deliberate indifference on the part of the defendants. The record does not support that the defendants were aware that by assigning Saldivar to a cell with a top bunk, she faced a substantial risk of serious harm, ignored that risk, and intended for her to be harmed. In fact, the record reflects that at the time Saldivar was reassigned to a top bunk cell, there was no bottom bunk restriction for Saldivar. At most, the decision to move Saldivar to a cell with a top bunk was negligence or a failure to ascertain a perceptible risk rather than deliberate indifference. Saldivar may not obtain relief on this basis. The record also indicates that she was not denied medical treatment. Immediately after her fall, she was examined and treated by the prison nurse. The prison nurse continued to examine and treat Saldivar from the day of the injury until she saw the prison doctor. The record does not support a conclusion that the defendant refused to treat Saldivar, ignored her complaints, intentionally treated her incorrectly, or acted in any way to evidence a wanton disregard for her serious medical needs. And this is a nurse, people. I mean, she
That's
should
the
be
greatest
able
distille I've
to
ever heard.
advocate for herself even more effectively than the average prisoner. But I don't
have any words.
I don't see her as all that smart.
No, I don't think so.
And I think I really do. I think she was in it because she thought it would be easy. You know?
Yeah.
So they affirmed the district court judgment, and they also gave a sanction warning that if she this was like strike one, so 2 more strikes on proceeding in form of pauperous, and she wasn't going to be able to file civil actions or appeals. So the cause was dismissed on September 29th, 2017. The court sanction warning was issued and the mandate issued on October 23rd, 2017. She tried to file another writ of mandamus, WR 69661-06, in the Court of Criminal Appeals. This time she wanted to get just certain portions of her record, and she's claiming the Nueces County clerk was not responding. And so the Nueces County clerk on November 30th, 2018, didn't have a record of an inquiry, but in accordance with what she was claiming, they sent a response that said it would be $176 for her to argue the specific portion. She wanted opening arguments by Valdez and Tinker, her attorney. She then wanted all the closing arguments by her attorneys and by the state. And so the total cost was going to be $189.65. The Court of Criminal Appeals denied her writ of mandamus without written order on December 19th, 2018. She filed another successive habeas corpus claim in the Western District, alleging that the prosecutor's due process clause of the 14th Amendment, the prosecutor violated the due process clause by withholding favorable exculpatory material evidence, which was the destruction of Selena's shirt by the hospital and failure to introduce Selena's white Reebok tennis shoes and baseball cap at trial, and that he abridged petitioner's constitutional right by subverting her equal protection of the laws by failing to introduce the white Reebok tennis shoes at trial, which were exculpatory material evidence because they didn't belong to Saldivar. Apparently, Carlos Valdez appeared on a Spanish-speaking show and showed the evidence from the case in 2018. And at one point, he showed a pair of blood-soaked tennis shoes, and Saldivar and her family got it in their little heads that he was saying the shoes belonged to Saldivar, and they had blood on them. And you know what he says to the media doesn't count, sweetie. So
yeah.
It's like it's an overly simplistic view.
Right.
So this is the wrong jurisdiction. You can't file this in the district court. You have to file it in the Fifth Circuit. So that was dismissed without prejudice for want of jurisdiction, and the case was closed. She never filed it at the Fifth Circuit, I don't think. But anyway, so then she goes back again for another 11.07 habeas corpus claim. She filed it in the district court in Nueces and then in the Court of Criminal Appeals, and it became WR 69661-07. She makes the same claims on May 31st, 2019, that with exculpatory evidence was withheld, consisting of a pair of bloody tennis shoes, which she says might have undermined the state's case. And if her attorney agreed with the state not seeking admission of the shoes at trial, his performance was deficient. The state answered, arguing that the present application is barred from consideration because the applicant filed a prior habeas application challenging her conviction, which was denied by the CCA after consideration of the merits, and she has not satisfied an exception to an affirmative finding for abuse of the writ. That the shoes belonged to the victim was a fact so well known at the time of trial that it made it into the papers. Thus, it's unclear why the state would now think they were the applicants, and she's failed to provide any proof beyond her bare allegations that the former district attorney ever said they were. In any case, the applicant's argument fails primarily because it depends on an imaginary trial where the state, operating under mistaken belief that they were her shoes, relied upon that evidence to meet its burden to prove her intent to kill. And in reality, the state did not use those shoes to prove intent or any other theory, so outside of her imagined scenario, the shoes are immaterial. The applicant also failed to make a prima facie case for actual innocence. Actually, the applicant makes no such claim, only that the state's evidence might have been insufficient if the trial had proceeded according to her imagined scenario. A claim of insufficient evidence is not the same as a claim of actual innocence. So the shoes belong to the victim. They were covered in blood after the applicant shot her. They are not newly discovered, and they are neither favorable to the defense nor proof of innocence. Because she has had her one bite at the apple, and the subsequent application satisfies no exception, the applicant has once again abused the writ, and her third application should be dismissed. The findings of fact were entered by the district court judge on July 5th, 2019. The clerk's record was submitted on July 9th. Saldivar sent a letter on July 17th requesting status, and on July 24th, 2019, the writ was dismissed without written order. She then filed a successive federal claim in the Fifth Circuit Court of Appeal, but that is just seeking the cost to purchase federal court records for her 2254 petitions, 2241 petitions, complaints treated as 2254 motions, and or 2241 petitions, and court orders disposing of her claims and magistrate judges' reports and recommendations issued in connections with those claims. So that was a letter to the clerk, actually. And so then she files a motion for leave to file an application for a certificate of appealability on October 16, 2019, challenging. This is weird. I think she's getting a jailhouse lawyer to advise her. She basically is challenging the dismissal of her state court writ in the Fifth Circuit Court of Appeal. I think she maybe wants to file a successive petition on those grounds. And on November 5th, 2019, the Fifth Circuit entered an order to obtain authorization to file a successive 2254 application raising these claims. Saldivar must make a prima facie showing that her claim relies on a new rule of constitutional law that was made retroactive to cases on collateral review by the Supreme Court and was previously unavailable, or the factual predicate for the claim could not have been discovered previously through the exercise of due diligence, and the underlying facts, if proven and viewed in the light of the evidence as a whole, would be sufficient to establish by clear and convincing evidence that but for constitutional error, no reasonable fact finder would have found the applicant guilty of the underlying offense. She has not made the required prima facie showing. Additionally, this court does not recognize freestanding claims of actual innocence on federal habeas review. Further, to the extent that Saldivar attempts to use actual innocence as a gateway to file a successive application, and assuming there is such an exception, her effort is unavailing. Accordingly, it is ordered that Saldivar's motion for authorization to file a successive 2254 application is denied. So that's the end so far. I wouldn't put it past this devious bitch to file something new based on, Valdez's interview in 2024 or whatever. So,
Yeah, I mean, she's totally cuckoo. I mean, you can't put a rational bound of thinking on people like this. So yeah, nothing would shock me.
yeah. So, anyway, now we move her parole. And I remember there was a lot of unrest about this topic.
Yeah, meaning they're going to murder her. She gets out.
Very funny memes on Twitter and Facebook. And a whole spectrum of people. I saw Hispanic people. I saw African American people. I even saw a couple of Asian people who had memes waiting outside of a prison with weapons for Miss Saldivar, the little troll, to wander out. Initial review the process began in October of 2024. That's 6 months prior to her eligibility date, which was March 3rd, 30th, 2025. In January, I think, stuff would have been submitted, but I didn't have any evidence of that, so I didn't add that. A decision was made on March 27th, 2025. Her parole was denied, and the reason was 2D, which is the nature of the offense, and this is what the parole board had to say. The record indicates the incident offense had elements of brutality, violence, assaultive behavior, or conscious selection of victims' vulnerability, indicating a conscious disregard for the lives, safety, or property of others, such that the offender poses a continuing threat to public safety. My apologies. I thought I turned that off. Her next review date is March of 2030, and I believe she will be 70 by then. So, that's it. Okay, so now I wanted to look at everything that's come out since these events. And I was surprised at how much it was. There was a book that came out in June of 95, Selena, The Phenomenal Life and Tragic Death of the Tejano Music Queen. The author was Clint Richmond. I seem to remember, though, that this was really panned as not a very good effort.
Yeah, I think you're right. I think that was kind of like a Hallmark movie of
it was a book or kind of like or maybe even like a like People magazine puts out these commemorative editions, like when the Queen died, and that I think it was along the lines of that. And it might have been based on an article that he did about Selena early on that was just adapted to add her death. There was E! True Hollywood Story on December 7th, 1996, Season 1, Episode 3, The Selena Murder Trial. A book called Selena Como la Flor, which was released on March 1st, 1997. The author of that book was Joe Nick Potosi, and he has appeared as kind of an expert on this subject on several documentaries. Loosely call them documentaries. Selena's Secret came out March 5th, 1997. The author is Maria Celeste Aris. Unfortunately, this book is awful. It's from Saldivar's perspective. It's very positive towards Saldivar, and it buys into all of her lies. And I seem to recall that I actually tried to read it, and she keeps talking about, I can't tell the secret. It's Saldivar's secret. I can't tell the secret. It's Saldivar's secret. And then she never actually tells what the fucking secret was. There's also an allegation that Selena was having an affair with a plastic surgeon in Monterrey, Mexico, that she had plastic surgery, which I do not believe because she never stopped working.
What do they think? She's still alive and she's or
No. They're claiming that
like
she
the
had plastic
ex-wife of the
surgery
surgeon killed her?
and she had an affair with a surgeon during her trips to Monterey. But the woman never stopped.
No. That's silly.
It's too good. She would not have had an affair with an older, as I understand it, a much older doctor who I don't think he wasn't like Brad Pitt. You know,
Right.
he in comparison to Chris, he was not superior.
Yeah.
And he initially denied it. This was all known at the trial. He initially denied it, and then in 2012 came out and claimed that he did have an affair. But again, I don't believe it. I think this is one of Yolanda Saldivar's lies. That
everything she says is not true. I mean, I wouldn't believe her if she said the birds fly.
If she said the sky was blue, I would go outside and look at it myself. Yes.
Yeah, exactly.
Exactly. Then Selena, the movie, came out March 21st, 1997. Writer-director was Gregory Nava. Producers were Moctezuma Esparza and Robert Katz, starring Jennifer Lopez, Edward James Olmos, John Cena, Constance Marie, Jacob Vargas, Lupe Ontiveros, and Jackie Guerra. You know the funny thing? Constance Marie actually auditioned for Selena and ended up playing Selena's mother. And the production was Q Productions, which is the Quintanilla family. Oh, and let me address this too. Yes, Abraham Quintanilla has been very protective of Selena's body of work and her image, and to the extent of engaging in litigation with anybody who said Selena's name. And there was litigation with Chris Perez when Chris Perez released his book. Again, I think it's Abraham is trying to protect his daughter, even in death. It wasn't fair, though, because Chris was a part of her life, and Chris should have been able to tell his story his way, and Abraham should have accepted that.
I mean, Abraham does come across as a little crazy. I mean, I'm not saying his motives aren't pure, but from an outsider, he kind of crosses the line.
He goes too far.
Yeah,
yes.
He goes a little too far.
But you have to look at it this way. Her music is still out there. I think the boutiques are still there. I mean, I think Suzette has done a phenomenal job of running them. Let me look. I'm gonna look online right now here. Let me see. Yep. I mean, they're on eBay. They're on Instagram. So I think they are. I think they are still in business, which is amazing. Oh no, they ceased operations in 2009. I'm sorry, my error. They ceased, but that's still a long time for them to have been in business.
Yeah.
So anyway, they were in business for a long time after she died. And you know, he's protecting her, and that's He doesn't always make the right choices, though. I think he should have allowed Chris to tell the story the way Chris needed to tell it,
Right.
and to have
Yeah.
respected that, and not to have engaged in litigation with him.
Yeah, he got kind of went overboard of thinking
Yeah.
he owned everything. And
So-
like you said, Chris had as much right to tell the story as he did.
Mhm. And then there's Behind the Music, which aired on March 29th, 1998, Season 1, Episode 22, American Justice. December 2nd, 1998, Season 7, Episode 7, Selena, Murder of a Star. Then there was a book, Justice for Selena, The State versus Yolanda Saldivar, which was published on October 11th, 2005. The author, Carlos Valdez, the prosecutor. To Selena with Love, was released November 5th, 2013 by Chris Perez. Snapped, October 5th, 2014, Season 13, Episode 15, Selena, Death of a Superstar. Real Crime, Real Story, May 29th, 2012, Season 1, Episode 1, Selena. Murder Made Me Famous, December 9th, 2017, Season 3, Episode 12. Selena's Secret was a mini-series, September 24th, 2018. Creator David Josky and Alejandro Almeida. Executive producers Francisco Cordero, Leonardo Arangabel, Maria Celeste Aras, Fernando Barbosa, Luis Balaguer, Ricardo Cueto, producer Mariano Carranzo. It was produced by Disney Media Distribution and BTF Media for Telemundo. There were 13 episodes, one season, and it aired on TNT. Did not watch it because it probably said, well, I can't tell the secret because it's a Yolanda secret. Selena the Series, December 4th, 2020. Creator was Moises Zamora. Executive producers were Jaime Davila, Rico Martinez, Suzette Quintanilla, Simran Singh, Hiromi Kamada, and Moises Zamora. 2 seasons, 18 episodes. I would recommend it. I watched part of the first season, or the first part, because I think it's 2 parts, not 2 seasons. And I watched the full second part, and it was really good. I ended up basically binging it over a weekend. So, but it didn't show the aftermath as much as I think it could have, because there was so much more that went on after. There is, in the court records, there's an email, March 1st, 2023, from Billy Mintz with instructions to send payment in self-addressed stamped envelope to the 14th Court of Appeals to obtain copies of Saldivar's court records, reporters' records, transcripts, and exhibits from her appeal. Another letter from Jupiter Entertainment on June 4th, 2023, seeking permission to send a production assistant to copy trial exhibits. The Selena and Yolanda, the secrets between them, February 17th, 2024 is when it aired. It was in 2 parts, so I think it might have been February 17th and February 18th. Produced by director Billy Mintz, executive producers Fernando Barbosa, Bud Bruntsman, Ruben Cannon, Mark Hefty, Billy Mintz, Mariana Perez, Patrick Reardon, Eric Strum, and Eric Weatherington. And Fernando was part of Selena's Secret. So this was just an extension of that bullshit. And again, it was just Yolanda's made up stories and manipulations, and her family, and everything her family talked about as, quote, new evidence was known at trial. Traveling together.
There's no new
a letter.
Nobody thinks anybody
from the attorney, and there was one other thing. All of that was known at trial. All of it was
Yeah,
addressed for
there's
Trump.
no. I mean, new evidence. That's actually. It's like a comedy show.
Mhm.
Nope, there's no new evidence. She did it. No one questions it.
And then April 29th, 2024, the Texas Defender Service sent a letter to the 14th Court of Appeals seeking appellate records for multiple cases, including Saldivar's. And then finally, on January 21st, 2025, Selena, a little golden book biography was published. The author was Maria Correa, and the illustrator Paula Zamudio. And I had my I'm sorry, I had my boxes get mixed up. The Secrets Between Them was 1 season, 2 episodes, Oxygen, Peacock, Bravo, and then that's in the Little Golden Book, and that was wrong. So yeah, even now they're publishing books about Selena,
Yeah, she's
and not the troll who killed her.
right. She's a hero. Everybody loves her.
Yeah.
I still remember all the everybody wrote Selena on the back of their window, their back windshields, and shoe polish.
Okay, that doesn't sound like a good idea. Because isn't shoe polish kind of permanent?
No, it's just the white stuff. The white shoe polish. You write it
Okay.
on windows.
Okay. No, I've never done that to a car. Um. But yeah, I mean, it was, and I feel bad for her family and Chris because this was. They had all started to see things that concern them, but they didn't realize how far Yolanda would go or
Right.
Saldivar would go. The troll. And I've seen when you look at the Reddit threads, there are people who call her Trollanda.
Yeah, I've said it before, but I still cannot believe she's still alive. I thought she would have been killed in prison, and if she ever got out, she would
Yeah.
not survive 24 hours.
Yeah. So, but yeah, that is it's 2025. This was 30 years. Selena would have turned 54 this year on April 16th.
Yeah, because she was born in
And
71.
Yep. So that is our episode, which bored Kyle to literally fall asleep, which you're never going to live down now. You realize this. I kind of heard it and I was like, is he coming down with something? And then I thought, well, let me take a break here and try and engage him. And then I realized you were sleeping. Adorable.
I have a little spring flu.
Yeah, that's kind of what I thought. So you're never going to live it down, but I still love you. It was hilarious. And but I was like, okay, this is boring. So, all right. And just a program note, we are going to skip next week because it's Kentucky Derby, and I know I will not get anything done. So we're not going to count next week.
But you were always winning on your picks for the Derby, though. You should start a channel betting on the Derby because you were always winning.
No, I don't.
You do pretty good, though.
I mean, I
mean, over time, you're definitely a winner.
I don't know. I mean, I'm hoping this year Sandman, Kentucky, Triple Crown Sandman. But he's in post 17. And 14 to 20 is
never wins. Wasn't that was it last year or 2 years ago that you had your favorite, but it was the same thing?
Yeah.
They were way out on the post from the post.
Well, yeah, one year my favorite was Mendelssohn, but he was 14 and he got freaking beat
Yeah, I remember that.
So, I haven't really picked anybody yet, and I'm gonna have to. I've got to find Joe Neville's haikus. I also need to look at the behind the stall door, not behind the stall door. What is it? The little foal. Every year, the Kentucky Derby contenders, they talk about what they were like as foals, because I'd like to read that. But my favorite this year is Sandman.
There it is,
At the
folks.
moment,
Put your money on Sandman.
Sandman. He's he's gray. He's pretty. He knows what he's doing. He likes his job, and he makes people pay a peppermint tax. And if they don't have peppermints, he does not deal with them. There was a video on Twitter where he's like at the little stall door, and the person doesn't have peppermints, and he's like turns around, goes to the back of the stall. Like, I don't have time for you.
Funniest thing ever.
But yeah. So we'll take next week off, and then we'll be back in 3 weeks. And Kyle, you're going to probably need to take some no-dos for the next episode, because it's another cray-cray.
It couldn't be crazier than Yolanda.
Oh, you haven't met Dee Dee Moore.
Buenos noches, Del Selena. Dee Dee Moore. Oh, goodness.
Oh, my God. Yeah. So, all right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 3 weeks for episode 6, State of Florida versus Doris Donegan Moore. In November 2009, Florida lottery winner Abraham Lee Shakespeare was reporting missing by his family. No one had seen or heard from Abraham since early April 2009. Dee Dee Moore had inserted herself into Abraham's life shortly before he disappeared. She claimed she wanted to help him, but her true intent was to help herself to Abraham's remaining assets, including his house and the remaining funds from his lottery payout. Once the police started their investigation, Moore's attempts to cover up the murder led police to her boyfriend's home, where they found Abraham's body buried beneath a slab of concrete. Moore was arrested in February 2010 and convicted in 2012. We'll talk about the evidence against Moore, her ever-changing stories, her antics during her trial, and her appellate and post-conviction claims. Until then, have a great 3 weeks and stay safe. Thank you.